The request made by the appellant was in terms turned down by the disciplinary authority in considering the importance of access of document in statement of witnesses to meet the charges in an effective manner. This court observed as follows. When a government servant is facing a disciplinary proceeding, he is entitled to be afforded a reasonable opportunity to meet the charges against him in an effective manner, and no one facing a departmental inquiry can effectively meet the charges unless the copies of the relevant statement and documents to be used against him are made available to him. In the absence of such copies, how can the concerned employee prepare his defense, cross-examine the witnesses, and point out the inconsistencies with a view to show that the allegations are incredible? It is difficult to comprehend why the disciplinary authority assume an posture and refuse to furnish the copies, notwithstanding the specific request made by the appellant in this behalf. Perhaps the disciplinary authority made it a prestige issue. If only the disciplinary authority had asked itself the question, what is the harm in making available the material and weighed the pros and cons? The disciplinary authority could not reasonably have adopted such a rigid and attitude. On the one hand, there was the risk of the time and effort invested in the departmental inquiry being wasted if the court came to the conclusion that failure to supply these material would be tantamount to denial of reasonable opportunity to the appellant to defend himself. On the other hand, by making available the copies of the document and statement, the disciplinary authority was not running any risk. There was nothing confidential or privileged in it. On an examination of the fact that in that case the submission on the behalf of the authority that no prejudice had been caused to the appellant was rejected with the following observation: be that as it may, even without going into minute details, it is evident that the appellant was entitled to have an access to the document and statement throughout the course of the inquiry. He would have needed this document and statement in order to cross-examine the 38 witnesses who were produced at the inquiry to establish the charges against him. So also, at the time of argument, he would have needed the copies of the document. So also, he would have needed the copies of the document to enable him to effectively cross-examine the witnesses with reference to the contents of the document. It is obvious that he could not have done so if copies had not been made available to him. Taking an overall view of the matter, we have no doubt in our mind that the appellant has been denied a reasonable opportunity of himself. We are of the considered opinion that aforesaid observations are fully applicable in the facts and circumstances of this case. Non-disclosure of document having a potential to cause prejudice to a government servant in the inquiry proceeding that could clearly be denial of a reasonable opportunity to submit a plausible and effective rebuttal to the charges being inquired into against the government servant. Stop.